Let me take incidents that are most recent. They are dominating our minds. An event happened on the night of 14th and 15th of March in New Delhi at the residence of a judge. For 7 days, no one knew about it. We have to ask questions to ourselves. Is the delay explainable? Condonable? Does it not raise certain fundamental questions? In any ordinary situation, and ordinary situations define rule of law, things would have been different. It was only on 21st March, disclosure by a newspaper, that people of the country were shocked as never before. They were in some kind of limbo, deeply concerned and worried at this explosive, alarming expose. Thereafter, fortunately, in public domain, we had input from authoritative source, the Supreme Court of India. And the input indicated culpability. Input did not lead to doubt that something was amiss, something required to be investigated. Now the nation waits with bated breath. The nation is restive because one of our institutions, to which people have looked up always with highest respect and deference, was put in the dock. It is now over a month. Even if it is kind of wounds, even if there are skeletons in the cupboard, time to blow up the can, time for its lid to go out, and time for the cupboard to collapse. Let the worms and skeletons be in public domain so that cleansing takes place. Not for a moment I will ever say that we must not give premium to innocence. Democracy is nurtured. Its core values blossom. Human rights are taken at a high pedestal when we believe in innocence till the guilt is established. And therefore I must not be misunderstood for casting aspersions on any individual. But then, in a democratic nation, purity of its criminal justice system defines its direction. Investigation is required. Boys and girls, no investigation under law is in progress at the moment. Because for a criminal investigation, the initiation has to be by an FIR, First Information Report. It is not there. It is law of the land that every cognizable offense is required to be reported to the police. And failure to do so, failure to report a cognizable offense is a crime. Therefore, you all will be wondering, why there has been no FIR? The answer is simple. An FIR in this country can be registered against anyone, any constitutional functionary, including the one before you. One has only to activate the rule of law. No permission is required. But if it is judges, their category, FIR cannot be straightway registered. It has to be approved by the concern in judiciary. But that is not given in the Constitution. Constitution of India has accorded immunity from prosecution only to the Honorable President and the Honorable Governors. So how come a category beyond law has secured this immunity? Because the ill effects of this are being felt in the mind of one and all. Every Indian, young and old, is deeply concerned if the event had taken place at his house. The speed would have been electronic, rocket. Now it is not even a cattle cart. A question we must think. There is a committee of 3 judges investigating the matter. But investigation is domain of the executive. Investigation is not the domain of judiciary. Is the committee under Constitution of India? No. Is this committee of 3 judges having any sanction under any law emanating from Parliament? No. And what can the committee do? Committee can at the most make a recommendation. Recommendation to whom? And for what? The kind of mechanism we have for judges, the only action finally that can be taken is by the Parliament when proceedings of removal are initiated. So a month has passed, more than that, and investigation requires speed, expedition, preservation of incriminating material. As a citizen of the country and holding position which I do, I am concerned. Are we not diluting rule of law? Are we not answerable to we the people who gave us the Constitution? And therefore, I would strongly urge everyone concerned to examine this as a test case. What legitimacy and jurisdictional authority does this committee possess? Can we have separate law made by a category and the law made by that category? Dehorse Constitution, dehorse Parliament. The committee report, according to me, inherently lacks legal standing. तो क्या हम ऐसे हालात में आ गए कि समय के साथ ये बात चली जाएगी? लोगों के दिल पर इस घटना से गहरी चोट लगी है. लोगों का विश्वास डगमगा गया है. There was a survey conducted recently, and the survey indicated, it was by a media house, that public confidence in the institution of judiciary is dwindling. It is fundamental for success of democracy that its three fundamental pillars, legislature, judiciary and executive, are above board. They are transparent. They are accountable. They exemplify to the people at large the highest standards to be emulated. And therefore, the principle of equality, equality before law, has been disregarded. It is fundamental to our democracy. It is nectar of our democracy. Time for us to enforce it. This is in March. Am I right? Still we are groping in dark. The tunnel is getting longer and longer, and light is not visible as to what will happen. Normal human tendency to forget an event because other events overtake us. This is not one such incident. I beseech everyone concerned to be highly alert, proactive, and restore authority of the Constitution. Boys and girls, let me take to you early this year. On January 27, 2025, a 7-member Lokpas bench, headed by a former Supreme Court judge, ruled it possessed the jurisdiction to investigate corruption complaints against High Court judges. Suo motu cognizance was taken. And mind you, if you go to other judicial dispensations, in other countries that have democracies thriving, suo motu cognizance is unknown to them. And then it was stayed on one ground, independence of judiciary. This independence कोई कवच नहीं है. This independence is not some kind of impregnable cover against inquiry, investigation, probe. Institutions thrive with transparency, with their being probed. The surest way to degenerate an institution or an individual is to give total guarantee there will be no inquiry, no scrutiny, no probe. How can we take this situation? These are serious issues. I am doing it. Let me tell you when it started. Constitution framers were very wise people. People who deeply believed in national welfare. They debated for 18 sessions for over little less than 3 years. There was no confrontation. There was no disturbance, no disruption. There was dialogue, debate, discussion, and deliberation. Very contentious issues. But they framed one rule. The judges will be appointed under Article 124. And a consultation word was used. Boys and girls, you know the word consultation? Lexicon defines it. Consultation is not concurrence. Consultation is consultation. Article 124 was very specific. And with respect to Article 124, we have a very important discourse by Dr. B.R. Ambedkar. And B.R. Ambedkar, who did a great job in giving us this constitution, I am quoting him. This was with regard to the question of the concurrence of Chief Justice. And Dr. B.R. Ambedkar says, I quote, boys and girls, for your benefit. I quote, I think to allow the Chief Justice practically a veto upon the appointment of a judge is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government of the day. And Dr. B.R. Ambedkar goes on to say, I quote, I therefore think that is also a dangerous proposition. But in the second judge's case, in 1993, the court interpreted consultation will be read as concurrence. Can it be done? The two words, boys and girls, are different. But the bench did not notice that Indian Constitution uses these words, consultation and concurrence, in the same article, Article 370. With respect to the then state of Jammu and Kashmir. Article 370 has both expressions in the same sub-articles. How can these two words used differently by the Constituent Assembly members in the Constitution can be read differently? It was done. Now, the situation is engaging attention of everyone. And it is our obligation as citizens of this country to think about how things have to evolve. I have no doubt Parliament cannot script a judgment of a court. I have no doubt about it. Parliament can only legislate and hold institutions, including judiciary and executive, accountable. But judgment writing, adjudication, is the sole prerogative of judiciary, in as much legislation is that of the Parliament. But are we not finding this situation getting challenged? I am saying so because very frequently we are finding that executive governance is by judicial orders. When executive, the government is elected by people, the government is accountable to Parliament. The government is accountable to the people at election. There is a principle of accountability in operation. In Parliament, you can ask questions, critical questions, because the governance is by the executive. But if this executive governance is by judiciary, how do you ask questions? Whom do you hold accountable in election? time has come when our three institutions, legislature, judiciary, and executive, must blossom. And they blossom best, and best for the nation, only when they operate in their own area. Any incursion by one in the domain of the other poses a challenge which is not good. It can upset the apple cart. The relationship between these three must be wholesome, soothing, one of deep understanding, coordination, co-liaising, not to show authority. Historically and also presently in many nations, judges speak through their judgments, and only through their judgments. Those good old days are gone now. We are having totally a different spectacle. A courtroom was the ultimate place from where a judge would pronounce his order